Right on, let's go, thank you. Right, members, the meeting is now open to the public. As ever, the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. It's proposed that oral evidence session with the Department of Justice on the Domestic Abuse and Civil Proceedings Act Northern Ireland 2021 post-legislative scrutiny will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Members, we are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest they wish to declare at this stage? Could I declare I have an immediate family member who works in the legal profession, please, and also that a number of us are members of the APG on access to justice. For those who have joined us in the public gallery, you're welcome to use mobile devices as long as they are muted and in airplane mode. And you can connect to Assembly Wi-Fi, and password details are available in the gallery rules. It's not permitted to take photographs or record any of the meeting. Agenda item 3 is draft minutes. Those can be found at pages 14 to 18 of the pack, and those are the minutes from last week's meeting, which was the 12th of June. Are you content that those minutes are a true and accurate reflection of that meeting?
Content.
That's great, then I will sign the minutes. Agenda item 4 is matters arising. We have none. Does anybody else? No. Thank you. Agenda item 5 then is Domestic Abuse and Civil Proceedings Act Northern Ireland 2021, and we're about to have oral evidence from the Department of Justice. Members, could I ask you to turn to pages 30 to 348 of your packs, please? And that's where you'll find the relevant papers. As well as post-legislative scrutiny of the Domestic Abuse and Civil Proceedings Act 2021, the oral evidence session today is going to cover a range of matters relating to domestic abuse. So the officials that we have with us today are Julie Wilson, who's Head of the Victims Support Division. Hi Julie, welcome back. Emma Crozier, Head of Violence Against the Person Branch and Victim Support Division. Oh, you know what the trouble is here? I can't see. I can read or I can see, and it's, you know. So Emma, very welcome. Thank you very much. John, Head of Civil Legal Aid Reform. John, nice to see you again. And Jane Maguire, Head of Civil and Family Courts Branch. Nice to see you, Jane. You're all very welcome. Thank you very much for taking the time to come and brief us on this really important issue today. I'm going to invite you to make your opening remarks, Julie, and then open to members for questions. Will that be all right? I appreciate it's going to be a fairly broad brush today. We've got a lot of information, so thank you for that. I'll hand over to you.
Okay, no, thank you. Thanks for this opportunity to brief you on the report and also on kind of the wider work that we're doing around domestic and sexual abuse. As you said, my colleagues Jane Maguire and John Bradley, they're here and can answer questions relating to domestic abuse and family courts and the domestic abuse waiver, respectively. If I turn first to the report under section 34 of the Domestic Abuse and Civil Proceedings Act, as you're aware, section 34 required the department to report on the operation of the domestic abuse offence, on child aggravators and on the generic domestic abuse aggravator. So this was the first report that's published under that legislation, and it covers the period from the 21st of February 22 to the 31st of March 2024. And as you know, we previously shared the report with you in March of this year. And I think the report and the statistics that it presents highlights why this new offence is so important. Just to briefly summarise, during the reporting period, a total of 1,757 domestic abuse offences were recorded by PSNI. Of these, 31 involved victims under the age of 18. 613 offences included child witness or other child involvement, and then a further 5,718 prosecution files included an offence that was aggravated by domestic abuse under Section 15 of the Act. Prosecution activity has significantly increased under the Act. In the financial year 23-24, there were 2,728 prosecutions involving offences under the Act, which was an increase of 67.9% on the previous year. Conviction rates have also improved, rising from 51.7% in 22-23 to 55.5% 5% in 23-24, and notably Crown Court outcomes have been particularly strong, with 88.2% of domestic abuse cases resulting in convictions in 23-24. The report identifies areas that are working well as areas where we need to focus our efforts. So domestic abuse contest courts, or DACs, and remote evidence centres, or RECs, are emerging as really promising innovations that allow complainants to give evidence in a safer, more supportive environment, and there are positive results here. There's been an 89% conviction rate across DAC sessions, and 2/3 of those outcomes were secured through guilty pleas without the need for the victim to give testimony. However, I should caveat that in that the cases that are heard in DAC sessions generally involve witnesses who are engaged with the criminal justice process, so we would expect to see higher conviction rates there, but nonetheless the results are noteworthy. Training has also been critical. Over 6,000 PSNI staff have completed relevant online training. PPS has established a multi-year training programme with Women's Aid Federation and the Men's Advisory Project, and Northern Ireland Civil Service staff engagement has also grown, with 2,081 staff completing the domestic abuse e-learning, which was up from 1,419 the previous year. We recognise that there's more to do here, and we've been working with Women's Aid Federation for Northern Ireland to develop a shorter, more accessible training package to encourage further uplift within NICS, but also cross-sectoral uplift, and we hope to start to roll this out after the summer. Obviously, concerted efforts across all criminal justice agencies are continue to be essential, and we aren't there yet. There is still more that can be done. For example, a key part of the report focused on victims' experiences at court, and this showed mixed findings. Some were positive, other findings, victim support referrals were inconsistent, with some victims not being connected to appropriate support until much later in proceedings. There were delays regarding confirmation of special measures, and we recognise that those kind of delays do have an impact on complainants, and agencies are working to address these areas. In some cases, the layout of court buildings has been problematic. For example, some witnesses reported that they came into direct contact with their alleged abuser in the courthouse. Being able to expand access to RECs beyond the current provision in Belfast, Craigavon and Foyle would help with this, but we are some way off being able to do that, although it is an aspiration. There's also been issues around communication, with some victims reporting that they felt uninformed, or that the language used was very legal and it was inaccessible. I think that's a broader point that's probably applicable to all victims of crime, and it's one of the areas that we'd like to address under the victim and witness strategy. We will work with partners to consider how to address these issues and to explore any other suggestions and proposals that have been posed. We plan to publish a second report in autumn of this year, and that will cover the period from the 1st of April to the 31st of March. And then after that, it'll follow a cycle of annual reports being published every autumn. And subject to the views of the committee, we would hope to publish the report on the department's website shortly after this session. If I touch briefly on the domestic and sexual abuse strategy and some of the key points of focus for us under that, work is progressing well. First of all, if I turn to the review of Northern Ireland's MARAC, or Multi-Agency Risk Assessment Conference arrangements, this is a really important piece of work for us. It's intended to strengthen how we mitigate risk to victims of domestic abuse. The earlier review by the Leonard Consultancy, it highlighted a number of areas that needed to be strengthened, and it recommended one recommendation, which was that Northern Ireland should step away from the MARAC principles and should develop a bespoke model for Northern Ireland. So we subsequently formed a working group made up of a wide range of statutory, voluntary and community partners. That group has developed recommendations for a new model, and they're currently being considered by a senior oversight group. So emerging recommendations focus on things like the overall structure, the frequency of meetings and the governance, how victims should be referred into the system, consideration of wider family issues, incorporating a perpetrator focus so that we can look at how to mitigate the risk that's posed by the perpetrator, not just the risk to the victim. The need for adequate and effective training, and the need to have really smart action planning, and for those action plans to be monitored and reviewed, and that assessment to be the risk assessment to be subject to review. So once the report has been fully considered and a new model has been agreed with ministers, we want to move very swiftly into an implementation stage with a view to prioritised recommendations, because I think this is going to be a big piece of work, but for prioritised recommendations being brought into operation in the second half of this financial year. If I touch on supporting victims, that remains a priority for us. Earlier in the year, we re-procured advocacy services for victims of domestic and sexual abuse, and we've awarded a new contract. As part of that, a new service will provide dedicated support for children and young people, and that's due to go live next month. Both the adult and children's services will be delivered by Assist NI, and in addition, I think your members are aware that a new children's sexual offences legal advice service delivered by Victim Support was launched in February of this year. We're also continuing to support the Domestic Homicide Review, or DHR, process. To date, executive summaries of 5 DHRs have been published, and we anticipate further reviews being published in the next few months. The learning from each of these is really important. I think equally important is that the recommendations are being implemented and being implemented in a timely fashion. We have now established a multi-agency working group to really focus on any cross-cutting recommendations and to drive those forward. And separately, the Department of Health has established arrangements to ensure that any recommendations for health and social care, that they're being implemented and that learning is being shared across trusts. In addition, we're continuing to work closely with PSNI and with other partners and stakeholders to develop a domestic abuse protection notice and order regime for Northern Ireland, DAPNs and DAPOs. And we've previously briefed you on the logistical and the resourcing challenges that we've been trying to grapple with on these. We're still actively working on this. As part of this, DOJ and PSNI recently visited one of the pilots in England and Wales where DAPNs and DAPOs are being trialled. That was really valuable. It's identified a lot of key learning that's going to help to shape what we do in Northern Ireland. We plan a further visit to a different pilot area that's taken a slightly different approach later in the summer. I'm happy to talk in more detail about some of the learning and the issues that have emerged from that visit. We've also recently hosted a roundtable policy workshop with key voluntary and community sector partners. Again, looking at what some of the challenges are, trying to look at what are the problems that we want to fix through DAPNs and DAPOs, and kind of almost, rather than trying to lift a model from England and Wales and apply it here, let's look at what are the problems and how do we fix those and how do we work around some of the issues and challenges that we have been experiencing. As well as these areas that DOJ is leading on, the strategy is, as you know, cross-cutting. So there's also been progress by other partner departments. In education, there's work ongoing on a new Northern Ireland curriculum framework, and that's going to inform any future education guidance related to domestic and sexual abuse. Department of Health is preparing a reflections booklet for social workers. Safe spaces have been established in all Jobs and Benefits Office, and the Housing Executive is progressing work under its Domestic Abuse Action Plan, and that includes training of domestic abuse advocates and improved referral processes into the Sanctuary Scheme, and we understand that that's already seeing increased use. So those are just a few of the areas that we've been focusing on since publication of the strategy. I hope you find it helpful. I appreciate I took quite a long time to talk you through this, but we're happy to take any questions that you might have.
Julie, thank you very much. No, it's great to have your overview because obviously it was a fairly extensive documentation on this subject. It's something that the committee does take a keen interest in, and we've had a lot of correspondence on, so we're really grateful to have you in front of us today. Who wants to start us off? Anybody got anything? I have a few bits and pieces I don't usually start, I usually go at the end, as you know, but if everybody's being shy today, then I'll I'll kick off. You had mentioned the stuff around DAPOs and DAPONs, Julie, and we've spoken about this before. Maybe you could highlight for us some of the key issues that you've learned from other places, and is there any concept of a timeline at this stage?
I'll go with the first bit of that. We visited in April. We visited the pilot in Croydon. I think the really striking takeaway from that has been the difference in the numbers that they're anticipating and the numbers that we've been anticipating. And I think some of this comes down to how you interpret the application of the legislation. The draft legislation that we've prepared is based very much on the legislation in England and Wales, and the thresholds are the same. How we reached our estimated numbers was by PSNI taking a dip sample and going through a sample of cases, and that had occurred, I think, during a particular time in the year, and looking at those cases and applying the legislation to see which of those they would have anticipated issuing a notice and then making an application for an order. When PSNI did that exercise and then they extrapolated it out over the number of cases over the year, they were coming at an estimate of 5,500 in the first year of notices being made, rising as there was familiarity with the legislation to 8,500. So really significant numbers. Obviously, the area within Croydon, the pilot area, is smaller than Northern Ireland, but in terms of the number of domestic abuse cases that they are dealing with, it's slightly smaller than Northern Ireland, but not hugely. I think it was 15,500, whereas it would be 18,000 roughly domestic abuse crimes in Northern Ireland. So comparable. Whilst our estimated figures have been in that 5,500 to 8,500 range, within Croydon they've been estimating 700. We've also been engaging with counterparts in Scotland who, when they've been doing estimates and engaging with Police Scotland, they've also been in that higher range. So there is a huge discrepancy or a huge difference between what we're estimating and what Croydon is experiencing. I think where our thinking is taking us is that it's almost inevitable that we're going to have to pilot any model because there is such a difference. When we've spoken with partners and delivery partners within community and voluntary sector, I think their expectation would be that the numbers would be higher than 700, which even if you were to multiply it to meet the population or have an equivalent population with Northern Ireland, you would still be looking at 1,400 there. So I think we are likely to conclude that the only way forward is to pilot within a police district and take the learning from that pilot as to then scoping what the impact of that would be across all police districts, all courts within Northern Ireland. So I think that's where we're going. But there are still some issues that we haven't been able to find an operational workaround. So I've previously explained to you that we had difficulties with meeting the time frame that's been put in place in England and Wales, and the experience in Croydon has been that they are also struggling to meet that time frame, but although for different reasons. I think for us there is an absolute difficulty operationally with police being able to bring a DAPO application within 48 hours, particularly where the incident happens in the middle of the night, which effectively would mean that they would have to bring a DAPO application the next day to be able to meet that 48-hour deadline. So I think we are going to have to look at what is reasonably practicable and in terms of that time frame, and whether we need to set a different time frame within Northern Ireland, a slightly longer time frame. So those are some of the issues that we're currently working through with police and with other partners. But I think there has been it was really helpful to see how the system is being run in Croydon, how they are using positive requirements. That was another challenge for us in terms of positive requirements would be, say, attaching, for example, the requirement to complete a behavioural change programme or a substance misuse programme. Yeah. And one of the problems for us when we've been looking at this is just the availability of those programmes within Northern Ireland. I think if we were to adopt an approach where we were to pilot within a police district, it would be easier to test the impact of those. It would be able to ensure delivery of those positive requirement programs, and it would also then be easier to test their impact as well. So I think we've moved forward. I think there's still a lot of detail that we need to work out. We're planning another visit to a different pilot. The pilots in England and Wales are being they're not all being run in the same way. There hasn't been guidance as to how the threshold in the legislation is to be interpreted operationally, so they're being interpreted in different ways by different pilot groups, and I think that's probably a significant point for us, given the disparity between what we're predicting and what Croydon has been predicting, but also in terms of the police response and how they're managing those, that's being managed in different ways. So in Croydon there's a dedicated team that is handling all of those. In other areas, I believe in Manchester, that it's not a dedicated team, so we want to look and see, how operationally what works best, what's the most effective in terms of the police response, but also in terms of the pressures being put on police and to manage these. So I think
the police going with you in these visits, Julie?
Yes, and I think after we met the last at the round table, we also there's been a suggestion that next time, I think it's a really helpful suggestion. So we're going to try to bring a representative from Women's Aid Federation as well. So there's a bit of coordinating diaries, etc., particularly over the summer, that needs to be done for that. But I think that would be really helpful. Certainly the roundtable that we had, I think, was really constructive and for us, but I think it was also constructive for our community and voluntary sector partners in understanding better what the problems are and what the challenges are, and then also having fresh thinking about, well, what are the ways around those. So it has been constructive.
You've clearly got a lot on the go, but timelines? Is there anything you're even aiming towards?
I think we would want to have a model pinned down by the end of this calendar year. I think in order to do a pilot, we'll need to revisit our regulations, our draft regulations. I think because it's secondary legislation, I think we would need to produce regulations for that pilot, and then at the point where you roll out, then we would need a new set of regulations for the wider rollout. So there are a lot of operational details that we need to bottom out, and not just with police, with courts, etc. So there is a lot that we need to grapple with. I would like to have agreement on a model by the end of this calendar year, but I'm scared to say that out loud.
I think it just gives us an idea of what you're aiming towards. We understand that things happen and stuff, but it gives us some concept as to when.
Yeah,
thank you. I have a few more bits and pieces here, and then I'll bring others in. The Cresswell review, Julie, I'm not sure how much you can tell us about that, but what I was wondering was, the work that you're doing in this field, and I appreciate that that review is ongoing, but also there have been police ombudsman's reports and reports from HMIC. To what extent are you coordinating everything that arises from each of these reports and making sure that all of the work is progressing together?
I think on Cresswell and Police Ombudsman, it's another part of the department that is leading on that. I mean, we are, we would be engaging on kind of the things that we're doing that where there are interdependencies. Yes. So say, for example, the MARAC review, which is different but has to take account of PPANI arrangements and things. So, but because I'm not leading on those, I think there's engagement, there's communication across business areas and across policy leads, but
no, I
I'm
don't
not.
expect. Yes,
Yeah,
no, I get that.
I feel a bit constrained to say anything about
you're not the person
in detail about it.
No, that's fair enough. I think what I wanted was, I mean, we've had a lot of reports recently about siloed working within the department, and what I want to be sure is that where there are subject areas, that everybody who's engaged in a subject area is moving in the same direction at the same time.
Yeah.
And that the issues are being taken forward holistically.
One of the I mentioned the MARAC recommendations, and certainly one of those recommendations is around the new MARAC. It won't be called MARAC because MARAC is a trade name or branded, but the new arrangements that would replace MARAC, that in taking those forward, we need to be recognising the crossover and the linkages and strengthening the linkages with what's happening in PPANI as well. So recognising that these are two different processes. PPANI is statutory, the MARAC arrangements are not statutory at this point, but they're both dealing effectively with protecting people, so there needs to be linkages and referral pathways and things. So and we will be progressing that with that in mind.
That's fair enough. Keep us posted on that.
Yeah.
I have a couple more kind of big general issues before I narrow down into a couple of things. We've had regular correspondence from a number of people. At this stage, particularly females who've been through the domestic abuse situation and had to go through the courts and so on. And the issues that they raise are similar to those contained within your report about re-traumatisation, about the court system being used as a weapon, all of those things. Now, that's not peculiar to female victims either. It is just a victim's issue. Have you made any progress on some of these issues?
I focus on the kind of criminal justice side, and then maybe Jane and John can come in on civil and family and legal aid sides. In terms of criminal side, both for domestic and sexual abuse and for wider, more vulnerable victims, we recognise absolutely that the criminal justice process, I think, is traumatic for anyone, and particularly where it's it's unfamiliar. Under the previous strategy, under this strategy, under Gillen, there are a number of things that we've been doing to try to mitigate some of that trauma. So it does come down to things like remote evidence, what supports are available either through victim support or through the Assist advocacy service. So there are things that we've been doing to try to mitigate some of that. To also, I think for anybody who's not familiar with criminal processes or with court processes in general, I think that of itself adds to that trauma. So there are lots of things that we have been trying to do to not make it, to take the trauma out. We are seeing the results of some of that, and I talked about the DACs and I talked about the RECs and some of the impact that we've seen of that. I think with the advocacy services, I mentioned that we've re-procured that, and in re-procuring that service, we have changed the model of it to focus Now, it does mean that it is now being focused on high risk, high harm victims. So it's a smaller cohort of victims who are being referred into that service. But the reason why we did that was to ensure that the support that was available under that service could be more meaningful within the available budget that we had, so that it's more intensive support and it involves face-to-face meetings, etc. So we've been doing things like that to try to support people, to try to reduce the trauma of attending court, of potentially, and I've recognised and I've read out that this doesn't always work, that there have been incidents where people have encountered
This particular reference to New Norwich and so on, are you having, along these lines, are you having conversations with the judges?
We've, in terms of LCJO, the Lady Chief Justice's office is represented on most of our working groups around Gillen, around victims' issues. So we're having those kind of conversations about how these policies can be delivered within courts, but it has been through the Lady Chief Justice's office rather than, in most cases, directly with judges.
That's fair enough. I mean, you'll appreciate, obviously, we've had meetings with the Minister about this and with the Lady Chief Justice and judges too, so that's why I'm following up on that. My last kind of broad brush, and then I'll move down swiftly into, because I'm conscious that I've got a queue of people wanting to get in. What I've experienced in my casework of late has been that because of the Ending Violence Against Women and Girls strategy, and it's right that there is such a strategy, but the result of that has been that whilst men are a third of the victims, and I've had this conversation with the police, I'm concerned at the lack of professional curiosity whenever men are claiming to be victims. And I'm worried that in the focus on ending violence against women and girls, men are not receiving the treatment that they should. Now, that is not to diminish from what goes on with women and girls, but I also believe that male victims should be receiving the same standard of service throughout the system. Are you doing anything or having any conversations to address some of these issues? And you can see that that's borne out in your victim survey results from male victims, because they face very specific and different barriers to coming forward and in the process.
Yeah, which we recognise and the strategy recognises, and we've always been really clear that that actually a third of victims is a significant minority. In terms of the police response, well, that will be a matter for police, but I know that they are alive to that and will be picking that up in training around the fact that that there are male victims and they will be sensitive to that. I
suppose I just want to make sure that they'll be scrutinised by the policing board, and that's not my job. But what I want to make sure is, and I've raised it with them directly, that they'll get their house in order, but as people move through the system, what is being done in the wider justice system to ensure that male victims receive the same standard of service that they should, and that because the spotlight is on violence against women and girls, that people don't remain in the shadows when they should be receiving equal treatment.
Yeah, and I think it's things like, I mentioned that we've re-procured the advocacy service as part of that re-procurement exercise. We said in drawing up our tender specification, we noted that there will be a significant minority who are men, and we asked anyone who was bidding for that to demonstrate how they would build in, to ensure that there are specific services there, that there's support that's tailored to men, to also kind of promote. And I think that's probably an area that collectively we need to look at, is how do we make male victims aware of the supports that are there, of the mechanisms that are there that they can access, that 24-hour helpline is also available to male victims. That assist is not just for female victims, but and in re-procuring that service, that was one of the things that we asked service providers to look at. So we do recognise it. Is there more that we can do? Yes, there is, and it's. I think there are a number of. There's probably a number of different work streams that will feed into this. I know that, for example, the Commissioner has done work around men and boys and their access to services. We have.
Yes, was at the launch of that report.
Yeah, I mean, and Men's Advisory Project are they're on the management board for Assist, and we've within the last year we've made funding available to Men's Advisory Project for things like work in Hyde Bank Wood with male victims and attendance at Marac and things like that. So we're alive to the needs of it. I think, is there more that we can do? Absolutely. And there are a number of work streams that I think will feed into that ultimately.
That's great. I just think in all of these things, no set of victims should be taken forward at the expense of another. They all deserve to be treated, the right way, and that's just what I want to make sure. I'm going to move now quickly and briefly to the Sejeni report, if I can. I want to take you first to Strategic Recommendation 2, which is about a service level agreement between the PSNI and the PPS. So there was, bullet 2, it was introduced in 2024 and be the subject of its first interim review in January 2025. Could you give us an update on the review of that? I'm going to give you these bang in order so that I can bring people in. If you could give us an update on the review of that service level agreement. And then, page 129. Yes. There's an issue there about the PPS not being able to update the PSNI when offences are missed, which seems to me quite serious. I'd like somebody to explain that to me a bit and then outline how it's going to be rectified, if you can. And then finally, it's operational recommendation 9, which members can find at page 150. This is about the court service. Let me see if I can get it. Yeah, this is about recording, about sentence enhanced and sentence not enhanced outcomes. Could you perhaps explain that issue and what the plan is? Because, insufficient progress probably isn't an ideal recommendation there coming from the Criminal Justice Inspector. So what's the plan? So those are my 3 questions, and with that I'll let you answer those briefly and then we'll move on to other members. Thank you.
Okay, on your first 2 questions, I don't have the detail in front of me, and we can write with more, but we would need to engage a bit more with PPS and PSNI on those and come back to you, if that's okay.
Yeah, that's fine.
On recommendation 9 then, so the sentence enhanced, sentence not enhanced, or DACE and DANA as it's known, that refers to when an aggravator is attached and how that's recorded, whether it's recording that a sentence has been enhanced or not. And I think the issue that Sejeni was raising, that in some instances there's nothing being recorded beside that. So I know they are doing work to try and ensure that that field is completed to get better data on how the aggravator is working and if the sentence is being enhanced as a result of that.
Is there a reason why it's not being completed?
Again, I think we would need to consult with our court service colleagues and come back to you, but happy to write to you on each of those.
Fair enough.
Yeah.
The reason I'm flagging up to you guys, appreciate that the PPS and the PSNI are not within your jurisdiction necessarily, but certainly the court service is within the department's jurisdiction, and I would want to understand what's happening there. If the recommendation says insufficient progress, then I think we need to be looking at that as a committee. So thank you very much. Now, my list is Maurice, Ciara, Connie and Deirdre. So Maurice, start with you. And apologies for making you wait. Maurice, are you still required to ask a question? I'll move on and come back to Maurice. Ciara?
Thank you. Just a couple. Just want to focus in on Section 36, the prohibition of cross-examination in person and family proceedings of the Act, which hasn't commenced, and the Department outlined some work that was progressed to date, but stated other work had taken priority. So just on that issue, just it would be useful to get an update on the status of that work, and maybe why more resources were not allocated to it, given that it is primary legislation. And then secondly, I would just, in relation to the waiver for eligibility of victims for civil legal aid, you did mention obviously the uptake was pretty low. I think 44 was noted in your report, and it was generally because people weren't aware of it and the general issues on part of family practitioners within legal aid work. So maybe could you provide kind of some specific details of the work the department is doing through the Enabling Access to Justice delivery plan to address the low uptake of the waiver? And then just thirdly, it's just the one other area, if we could just look at, obviously so Jenny recommended that within 6 months of the publication of their report, the Department of Justice would review the relevant sections of the Act to introduce a presumption of a personal connection, allowing for this to be challenged by the defence in appropriate circumstances. So if you could provide us where we update with regards to the progress that's made on that, and that work what's the momentum in relation to bringing that forward. All right, thank you.
Are you able to talk about prohibition
yes.
of cross-examination, and then John on the waiver, and then Emma will talk about your third. Thank you.
So on the prohibition of cross-examination in family proceedings, there is quite a bit of work required to implement that, quite a bit of secondary legislation in particular. A lot of work has been taken forward so that if under the provisions, if a party was to be prohibited from cross-examining in person, the court is able to appoint a legal representative to carry out the cross-examination on their behalf. So one of the requirements under the Act is for there to be guidance on that role. So we have prepared draft guidance and engaged with the legal profession on that. The legal representative would be funded by the department. So we've done quite a lot of work on developing a proposed fee scheme. And again, we have engaged with the profession on that. Under the legislative provisions, we need to specify certain criminal offences, certain protective orders, and other types of evidence of domestic abuse, which would trigger an automatic prohibition, and those all need to be specified in a statutory rule. So we did a consultation on the issue of other types of evidence of domestic abuse, and we have that collated, and we do have a working draft of a statutory rule to give effect to that. So also court rules are required in support, and we have progressed work on that. There was also a project sort of group established together with colleagues in the court service and in the Lady Chief Justice's office, just to in terms of the operational arrangements to support it, particularly around how payments would be administered to court-appointed legal representatives. So there is a lot of work that has been done. Unfortunately, we're a small team in the branch, and it has been impacted by other just more priorities that we've had to take forward, some of which have had particular timescales. But we do hope to be able to implement that as soon as possible, and hope to be able to get back to it over the summer when hopefully everything else maybe just quietens down a little bit. So, but I can assure you that remains a priority, and we're trying to progress it as soon as possible.
There was no suggestion, I'm just conscious of the various amendments in this bill, that it would have been seen as more appropriate to try and ensure it was included within this bill. Is it solely just down to resources, or how was...
Nothing else would be required in primary legislation. It's secondary legislation that is required in support, so a number of statutory rules would be required. But as I say, a lot of work has been done to prepare those. We just have still a little bit more work to do.
Do you think it'll come forward this mandate?
I would certainly hope so. I mean, we would hopefully we might be able to progress that in this business year. So that's certainly what we're aiming to do. But sometimes, other things come up. But as I say, we'd hope to progress that as soon as possible.
Okay.
Okay, Ciara, is that you done?
I have two more
You have two more?
answers.
Sorry, apologies.
Yeah, the section 28, the financial eligibility waiver for victims of domestic abuse, just to update the figures, it's not a huge improvement. Up to the 23rd of May 2025, so that's a few weeks ago, there are now 51 successful applications for the waiver. For completeness, I believe there were 7 applications for the waiver where it wasn't granted. That's a combination of, I think, some of the people had applied for the waiver who didn't need it because they were already financially eligible for legal aid and therefore weren't granted the waiver, and the remainder were people who didn't provide the documentary evidence required to satisfy the evidential test that they were in fact eligible. Based on the work of the outcomes commissioned by the department to support its review that's required under section 29 of DACPA, based on the foundational review of civil legal services that the department's undertaken and the further rapid review and priority setting exercise that was conducted to support that. It appears there's 2 principal reasons for the lack of uptake. Number one is, as you say, awareness. Despite considerable efforts by the department to make sure that all legal representatives are aware of the waiver and direct engagement with community and voluntary sector organisations that work directly with victims of domestic abuse to make sure that they're aware. It's very difficult to increase general awareness in the public of the availability of the waiver because it's not relevant information to anybody up until the point where they need it. And if you can't communicate at that exact moment to that they might be eligible, they won't be aware and they won't claim. The second issue with it is we've been told by a number of legal representatives that the remuneration available under legal aid terms isn't sufficient, and that they prefer only to take these cases on a private paying basis. So we've got those 2 things to address. As far as response to that, in the delivery plan for the Name and Access to Justice programme, published for consultation a little while ago, there's 2 actions in there that are going to speak to that directly. One of them is the review of the financial eligibility rules for legal aid in the round, because one of the things we can do there is to look at the circumstances in which it isn't necessary to conduct a financial eligibility test at all. So it isn't that there's a test which is disapplied by a waiver, but we can do things like, say, in circumstances where a person is a victim of domestic abuse and they make an application for specific types of legal aid, that there is no financial eligibility test in those circumstances. The benefit of that is what you can do is you can make sure that they have a comprehensive set of legal supports rather than the narrow legal support that's available in specific circumstances through the waiver. You can make sure that all of the types of legal aid that a person might need as a complainant in criminal proceedings, perhaps as a witness in criminal proceedings, or as an applicant in private family law proceedings, or an applicant for a non-molestation order or for a DAPO or whatever, they can get all of that eligibility in one application without having to go through repeated tests, repeated financial and different rules for different things. So one opportunity to tidy that up and make it simpler and clear for people is through that financial eligibility review, which forms part of the delivery plan. The second one is that there's an action in the delivery plan to look at improving specialist support specifically for victims of domestic abuse and for a few other groups. And the main thrust, I think, behind that is going to be looking at how we get the support that's available through legal aid integrated into the other forms of support that people are getting, eventually such that when a person becomes a victim of domestic abuse and goes and reports that to someone, whether that's Women's Aid or the Men's Advisory Project, whether it's the police or their GP or whoever, that the the legal aid system comes to meet them where they are. And so you can have signposting from other service providers to providers of legal aid. And they can therefore be made aware at exactly the point when the legal aid is necessary of their entitlement, and be signposted to someone who's doing that work and who specialises in it. The other thing that we'll have to do as part of that, though, is to address the fact that legal aid practitioners are telling us that the remuneration rates for this are insufficient to get them to do the work. So there's no point in all of the rest of it unless the pay is there. So the thing we'll have to look at, as we said we'll look at as part of the improving specialist support for all of these things, is to say this is early intervention, this is an extra skill set, this is a set of skills and knowledge for which the department is prepared to pay a premium, and to set an appropriate level of remuneration for those types of services where we can
Also quite
construct them.
onerous, isn't it? I mean, the process is really onerous, and so solicitors are like,
What's the point? That's
This is
the
it.
feedback
And so
I'm getting. So.
if you can imagine a system where at the minute you've got to make an application, you've got to submit evidence and so forth. What we're hoping to move to is a system where if you go to, well, let's say it's your GP in the first instance, you make that report. When they're doing the signposting, they simply give you a document in doing the signposting, which is enough essentially to bypass all of the application, the financial aspects of the application process. Because by making it an exemption in the financial eligibility test, it takes away a lot of the administration. With the waiver, people have still got to supply information about their finances so that the levels of contributions and so forth that they pay can be calculated. Whereas if it's taken out of the financial eligibility test entirely, you simply demonstrate your eligibility and move through it. So it should be that much more streamlined as a process. But the work that needs to be done there is to work out what is the package of support then. What does that look like? How does that integrate with the other forms of support that are available to people in these circumstances? And how is it best integrated into that suite of services? So that's what those two actions together in combination are intended to try and overcome some of these barriers to uptake.
No, I'm pleased that is happening. I think it's really important because it's all fine and dandy. Oh, there's a waiver, but if
Yes.
it's in reality, it's not really assisting people. And then you have solicitors who saying, "I'm not going near it. What's the point?" Because it takes that much time and hours, and then they have to travel. And then the specialisms as well. I know we have a bigger issue regarding the availability of solicitors that would specialise in this work.
Absolutely.
So it is. But no, it's good to know that it is.
Yeah.
There is key actions within the plan, and you are working towards it to try and ensure that it's way more effective. So thank you.
Personal connection then. So as you mentioned there, the 2021 Act as it stands requires a notice of personal connection. So Jenny have found that it's very resource intensive for PPS, and also the victim is required to sign that as well. So I think the recommendation would turn that on its head so that there would be a presumption of a personal connection between the two parties, with obviously the opportunity to challenge that, but it would take that away, because when Sejini finished their latest report at the end of 2024, there had only been one case where a defendant had challenged that they had a personal connection. So yes, we accept that recommendation. We've spoken to PPS about it, and we've sought views of the Bar of NI and the Law Society. I suppose the blockage is getting a legislative vehicle to make that, because we need to make change to the primary legislation. But yes, I suppose it's not in the bill at the minute.
It's not in the bill. I think we would struggle with capacity in doing that. We've said that we'll do some of the policy thinking, but a bit like Jane, in terms of our capacity, because we're working on things like depots, because we're working on that MARAC review, and we've prioritised those because of how important they are, I think we would then also struggle to do the policy and the instructions on a piece of primary legislation as well. So that's something that we intend to do for sure, but we think actually the changes to MARAC are where we need to focus our efforts at this point, because I think they will result in really significant changes to how people are safeguarded, and to that kind of lowering the risk that people face. So it's something that we want to do, but we'll do the preparatory work within this mandate, but we see it as the legislation is likely to be next mandate.
Okay, well, thank you.
All right, Ciara, thanks very much. Connie?
Thank you. Thanks for coming in today. I wanted to talk about one of the reports included there. So it was the one that was published in August 2022 that the department commissioned into the experiences of victims and survivors of domestic abuse. And there's a number of recommendations in it, but I'm quite very interested in the recommendations specifically around the family courts, and that's something that this committee's been contacted by people with negative experiences, and I have as well through my constituency office. So I'm just interested to know how the department, or if the department is taking forward these recommendations that are in the report.
Can I turn to you again?
Yes, I'm just going to get the specific recommendations in front of me. I think the original context for the commissioning of this report was to inform the statutory report the department's required to produce under Section 29 of DACPA. Section 29 is actually reasonably narrow in terms of its provisions, because it talks about the department bringing forward proposals to reduce the cost, including to zero, of being involved in family court proceedings for victims of domestic abuse, and to reduce the capacity of those proceedings to be used vexatiously to continue abuse. Obviously, having read the report that was produced in August 22, goes considerably wider than that, and one would expect so in terms of dealing with the multifaceted nature of the experiences of this specific group. As regards the specific recommendations to deal with the operation of the family court, we've referred those to the Lady Chief Justice's office for consideration insofar as they concern the operation of the courts and court procedures themselves. In terms of our response to trying to mitigate some of that impact for people, it's focused in the legal aid terms in the two actions in the reform programme that I mentioned previously, which is trying to ensure that people who are going to be going through these processes have specialist and comprehensive support available to them, so that they go in with an understanding of what they're going to be facing in the courtrooms, and with enough support, professional, legal, and also emotional and advocacy support, to cushion them against some of the, what we're told is often traumatic experience that they're likely to be going through in the court process. The committee members will also have seen the rapid review and priority setting exercise report that we published alongside the foundational review, and it speaks in really quite frank and shocking terms at times about the experiences that people have in these processes. By and large, people tend to say that they are grateful for and welcome the support that they've had from the legal representatives involved in providing their work, and say that it would be a much worse experience without that. What we're looking at is whether, well, what our assumption is that there's probably something more and something further that can be done rather than simply providing legal help, and that's what we'll aim at through the action on improved specialist support for domestic abuse victims.
No, I appreciate that, and I think the report highlighted some concerns that I think are raised with us
Yes.
consistently, and think especially when it comes to, you know, victims of abuse being re-traumatised or feel they're not being taken seriously or listened to in the family courts, and
Yes.
also the voice of the children, and it also speaks about a pro-contact attitude within the family courts, and I think a lot of people who have had these experiences feel quite frustrated, and we have met with the LCJ and also put this to the judiciary, but I just would like to know a bit more around how do you see the department being having a role in driving some of these recommendations forward?
I think obviously we have to respect the independence of the judiciary in so far as how their independence to decide how these proceedings are conducted, and the prominence that they give to different voices and different principles. They're legal matters for decision by the judiciary. The hope and expectation of the Enabling Access to Justice Delivery Plan programme is that if you can make sure that people are going into these environments, I should say, Lady Chief Justice is aware of these issues too, and I'm quite sure it is working towards making that process a better experience for people who are there. What we hope to be able to do is by giving people specialist support and comprehensive support to influence the culture of the courtroom to some extent, so that if we have solicitors, barristers who are going into the courtroom who are trained and experienced in trauma-informed practice, who have a focus on reducing the levels of re-traumatisation and giving prominence to voices that aren't always heard, that starts to shift things in a positive direction from that perspective. But in the end, it'll need to be done in partnership between the department, the legal profession, and the judiciary.
I just make one wee comment.
Yes, go ahead.
Just in relation to, I'm a bit concerned. I would like to see way more cross-departmental work done on this, given the concerns that have been raised, not just within the report, but what we have discussed here as a committee and in our meetings with the Attorney General, etc. And then likewise, and even with the Department of Health as well.
Yep.
So it's kind of getting that fuller picture, because we're hearing the same concerns. And I'm not hearing enough, personally, I'm not hearing enough of kind of actions to kind of drive the change that's required. And I know it's just not in one area. It's like the voices of children is really important, and there's some aspects of advocacy there, but there's not enough across the courts, etc. So I'd love maybe, and I know we're hoping to kind of do more around this come September, but I would think between now and September I would like to kind of hear more from the department on what cross-departmental work is being done, unpacking all the concerns, whether it's through a report, whether it's through this committee, that have been raised to date, and maybe what changes collectively across all the departments we could kind of help to drive forward, if that's okay. I don't want to put you on the spot, because I know it is complex, and I know it's not just about this
sensible.
Department, it's across a number of departments as well.
That's the thing that's thrown up by the reports that are conducted in all these spaces, is they all present a complex and a multifaceted picture. And so if you try to approach it from a purely legal aid perspective, you try to approach it from a purely criminal justice perspective, you don't capture everything that's there, which is why a lot of what I'm saying about the improvements to legal aid is really about integration. It's really about making sure that we're joining up where we need to.
I think some of the devil is in the detail around that. You talked about unpacking, and I think unpacking what that piece around specialist support looks like, and that's the piece that we need to do, is kind of the join up, and that's not just the join up between civil and criminal side, but also, as you say, then what does that mean in terms of child protection and health and social care, so I think it's in that unpacking piece where that will come together and needs to come together.
It's the right approach.
Okay, yeah, no, thank you.
Okay, thank you, Ciara. Deirdre, and then Justin, could you let me know whether or not you still want to come in on this? Okay, if you do, will you put your hand up for me? Thank you. Deirdre?
Yeah, no, thanks very much just for your answer so far. I suppose report under section 29 of the Act, so just around the legal aid. You had said that was to be let within 2 years, and obviously there was reasons for it, and it's going to be let in the coming weeks. Is that before recess? Coming weeks, or will it be after?
I don't know. The plan had been to lay, obviously we provided a written briefing on the report, and the plan had been, following the committee's consideration of that written briefing, and depending on your views, the plan had been to get it in before recess. What I haven't done is rework the timeline based on the fact that we're considering it today.
Yeah.
But I will say, if at all possible, it'll be before recess. But just if we may run out of days, depending on and depending on what further questions you guys have.
No worries, thank you. The other bit, sorry, give me 2 seconds because I've just moved off it here. The other bit, sorry, yes, was around obviously the Criminal Justice Inspectorate report back last year, and then the updated report this year as well. And obviously there's been good progress on many of the areas of the recommendations of 8, but there's also been not so good progress or insufficient progress in terms of the courts and tribunals. And I suppose it was to Joanne's point in terms of recommendation 2 of last year's report. It obviously looked at that area in terms of the PSNI and the courts as well. And then when you look at the experience of people going through the system, I mean, there's been some good areas, and I suppose it's just to recognise that as well. But the negative feedback is around timescales, lack of clarity and available support, appropriate referrals. And I suppose it's just feeding into that issue of a siloed approach at times on a separate Criminal Justice Inspectorate report. So it is just to get a sense from yourselves then what is being done to rectify that, and particularly moving the insufficient up to actually good progress being made. Is there a focus being looked at? And even in terms of the access to justice stuff, is this an area of work where there's a priority? And the other part of the report as well, it talked around the need for increased training and awareness within the PSNI and stuff as well. And it's just do all these things correlate then, if they're falling down on certain aspects, is the appropriate training and support being put in. So I would just like a wee update kind of on those areas.
I think on the point about referrals, I think that's not always limited to domestic cases. I think it can be, it's an issue that I know has been raised at, I also chair the Victim and Witness Steering Group, so it's been raised at the Victim and Witness Steering Group about kind of referrals to victim support, and it's something that's actively being looked at by police and victim support to look at, well, why are there some issues around that kind of referrals into support services. So that is actively being looked at, and hopefully also kind of proves the point that it's not just sort of siloed work, and it's being looked at kind of strategically as well as in this context, sort of in the wider victims and witnesses issues forum. Sorry, you're going to have to remind me.
I suppose it was the Criminal Justice Inspectorate where they said there was insufficient progress or no meaningful progress in terms of a number of the recommendations that were made last year pertaining to the PSNI and courts and tribunals. So obviously this is the front facing end, and that's the concern in terms of the impact on victims and witnesses. So what specific work is the department doing to rectify that, considering it was a recommendation back in April last year? And there's still insufficient progress in their update report this year. So
I think on the PSNI ones,
yeah,
they are, I mean, I think that falls to PSNI too, and on some of those I will write with an update on those, because they are for PSNI and PPS to progress. On the courts one will also write. There were a couple of others for the department, so the one on that we've just discussed, and then there were the other ones were around raising awareness of statutory guidance, so that has been a focus, and there was also one on, and I touched on this in my opening remarks, on the sort of low uptake of domestic abuse training across the civil service. So that's something that we have also been working on with Women's Aid Federation. Emma, do you want to talk about both of those briefly?
Yeah, sure. So on the e-learning package, we are working with Women's Aid and other voluntary organisations who helped us to develop the initial one. It was a 4-module pack, so the feedback we received was that it was maybe too long and too detailed. So we're working to revise that, to shorten it, and then roll that out again across civil service and other sectors, health and social care as well. Julie, yes, she also mentioned the guidance. So under our new strategy, which began end of September last year, we have new governance structures in place. So we've got the Strategy Oversight Board, which Julie and her colleague in Department of Health chair, and the Expert Reference Group. So when that group first came, we presented the guidance as a key document that set out, I suppose, terminology. So we were all working to the same common terminology and things like that, and yeah, we will regularly refresh that and bring it to those groups on those two recommendations.
I think you also mentioned police training, and again, I'm not in a position to give detail on police training, but I know that I think there's been a number of different modules that have been produced that it's domestic abuse training is being introduced from kind of student officer stage. I know that over 6,000 officers have received the first module, and then that's also been supported by I think learning forums and things like that as well. So and they're now looking at the rollout of those additional modules, and I think it's about how that's choreographed across police officers.
And I suppose it's important, I would like clarity then if you were going to get that update from the police in terms of the insufficient progress, because in the Criminal Justice Inspectorate report in this year, in terms of training, obviously they're saying there's still more work required for police officers, but also staff working in frontline contact management roles in terms of improving the quality of their threat and risk assessment, so like their critical issues in terms of supporting victims and witnesses. So if we could just get an update then. I know that report was only in April, but a progress on what they're doing to rectify, because obviously even for the officers themselves, that training, will support them also. So I'd be keen just to get an update on that as well. That would be good.
Yeah, and there will be, I mentioned the work that we're doing around the risk assessment conferences, and one of the key recommendations around that is around the training that is needed, so for the officer who's going out to attend an incident, but also for everybody who's involved in that process, and assessing risk, understanding the dash form, etc. So that's been recognised, and that will be built into our work plans.
And she said to the importance of the same language and stuff being used as well across the different areas of work. My other one was just around then, obviously, because I know some of the recommendations coming out was in terms of work with education, and particularly the impact on children and young people as well. So it was just to see what work the department is doing with education around capacity and skills, and also promoting the understanding of consent and positive relationships. So just to get a wee sense of an update on that. And then I think you'd mentioned, Julie, earlier around work being done. It was, work coming from a round table around domestic abuse protection notices and orders. So it was just to see what is coming out of those round table discussions in terms of work then going forward in those two areas. And that's me. Thank you.
On the education piece, first of all, so Education has established a Healthy Relationships Forum, which the department is represented. TEO ZBOG team are also represented on that. Education have indicated that they want to develop guidance around domestic and sexual abuse, but that needs to kind of flow from the work that they're currently doing on the Northern Ireland curriculum. So that takes, or the curriculum framework, so then that will flow from that. There has been, you'll be aware of the police-led campaign, which we had provided funding for, but also the TO were involved in developing the Power to Change. And a lot of that is around healthy relationships and respect agenda. PSNI and TEO are both then working on kind of the next phase of that, and how those principles can then be applied in different settings. And I think some of that will focus on education and youth work, etc. But that's still work that's just kind of being developed. Although TEO have worked with young people to develop an associated game that kind of explores those kind of issues. Education is represented on our domestic and sexual abuse strategy, so and all of the kind of the commitments that the Department of Education have put into that they have they've identified, and we will work with them to support them on that. Again, you'd asked then about the round table on DEPAs. I think for me, some of the really important points that came out of that was, I think it was a really useful forum for our kind of community and voluntary sector partners to understand in better operational detail why we've been finding this hard. And I think that was really, really positive. From my perspective, I think one of the things that we wanted to look at was what will these add over and above police bail conditions? What will these add over and above NMOs? And really kind of crystallising that actually the biggest added value that they will bring is not having the victim take the action themselves, and what that does in terms of lifting some of that onus that John has been talking about of, you know, having to, you know, engage with, you know, legal aid and things like that, but also just not having, you know, it is a positive proactive step to have to take to apply for an NMO. It is complicated, etc., but actually having that taken out of your hands, and it's actually, you know, the police doing that takes the onus off the victim, and it becomes part of the protective arrangements, and that very much was the strongest, really strong point that came out of that. But I think it's a really important point, and I think if we are then looking at piloting, you know, do we focus on that police-led? Interestingly, in Croydon, most of the, I think with the exception of maybe one or two, all of the DAPO applications have been brought by police, and they're finding that victims of domestic abuse are still taking action, but they're applying for NMOs rather than DAPOs. I mean, we are familiar, everyone is familiar with the issues around NMOs, but I think for me it was really important for us, it was really important to just get that message that actually the whilst you don't want to take agency away from victims, this isn't about taking agency, it's about actually removing the responsibility and removing the onus to actually do this, and someone else, police, will do it because it should be being done. So that I think was a really important lesson.
Oh, thank you for that. Cheers.
I do agree. Justin?
Thank you, Chair.
Thanks, Chair. Hi, Julie, Jane, Emma, John, how are you all? My question may have been touched upon, but just don't want to probe it further, right? It's concerning, particularly with frequent discussion around the Victims' Charter and around encouraging victims to come forward and ensure that they can access justice, that there is evidence of victims not being referred to services or not being made aware of services that exist to support them through the legal process. Can you explain why this is happening, and how is the department going to urgently rectify this reality?
I think one of the issues is that we are looking to see, and particularly police are looking to see why this isn't happening in all cases. In some cases, I think, in some cases, a victim may opt out of a referral, and certainly when police are referring into victim support, there is legislation in place to allow police to make a referral to victim support without the express consent. So a victim has to opt out and say, I don't want a referral to be made. Police are unable to do that. I think there is an issue, though, that has been identified that it's not happening in every case, and we are actively looking at that. Police and victim support in particular are looking at why that's happening, and the Victim and Witness Steering Group is monitoring that kind of piece of work to see why isn't this happening. I think there are other potential support services where that where a victim has to give their consent, where it's not opt out. So there's legislation that says that for victim support and NSPCC, police can make that referral. Unless someone says, no, I don't want a referral to be made, they can just go ahead and do it. For others, that police will need to say, I can make a referral for you. Are you content? So that, and so I think there is a question as to whether victims are not giving their consent. I think there are also questions as to whether those questions are being asked in the first place. So I think this is something that is going to have to be looked at operationally to see why. But we're aware that there are issues, and we are actively looking at that, and we are monitoring as that work is progressing.
Operationally, is that not a major red flag?
I think it is something that we're treating seriously, and that has been, that we are looking at. I think ultimately having those processes in place to ensure that happens, having the training in place, the familiarisation in place, the awareness, that's a matter for police with their officers to make that happen. But I know that they are looking at that to ensure that they improve that referral rate. It's not just domestic and sexual abuse cases, though. I think it is an issue that is wider than that, which is being looked at.
I think at this day and age it would be more than being looked at, wouldn't you?
I think they need to look at it to understand why it is happening. They're looking at it in order to address it. So yes, they're looking at it, but with a view to improving the position.
Okay, listen, ladies, thank you very much. Thank you for your evidence and your very important work. Thank you.
Thank you.
Okay, Justin, thank you. Morris, earlier on you had indicated that you wanted to come in and then your hand went down. Do you want to come in?
No question answered quite well, John. So I took my hand down once I heard the answer.
Oh, that's
But,
great. Okay.
Very good presentation. Thank you.
Thank you very much, Morris. That's great. Okay, everybody, does anybody have anything further? Are we happy enough we've covered the ground here? All right. Folks, can I thank you all for your time and your evidence today? We really appreciate it. As I said earlier on, this is an issue that matters to the committee. It's a priority for us, and we're very grateful for your updates. Before you leave, you may want to know, members, are we content now for the department to go ahead and publish the report, which you can find at page 56? Content? Agreed, right. Thank you very much indeed. Everybody, thank you. Enjoy the rest of your week.
Thank you.
Members, can I have your agreement to move back into closed session for a briefing from the examiner's statutory rules regarding the SL1 on the PACE codes, please? Our members agree that we'd go back into closed session? Yes?
Yeah.
Thank you.
Committee Room 30. Sound.
Let's go. That's us back into open session. Thank you very much. We're now going to, in the public session, consider agenda item 7, which is SL1, the Police and Criminal Evidence Northern Ireland Order, Codes of Practice Order 2025, essentially known as the PACE codes. I would ask members to turn to pages 350 to 405 of your meeting pack and pages 25 to 79 of your tabled pack for the relevant papers. By way of reminder, members, the Department proposes to make a statutory rule under powers conferred by the Police and Criminal Evidence Northern Ireland Order 1989, PACE NI. And the committee has previously considered the rule at meetings on the 27th of February, the 3rd of April, the 22nd of May, and again on the 12th of June. Follow-up information was provided by the Minister of Justice, and that outlined potential options for a way forward on amendments to the PACE codes. Option 1 was to wait for guidance from the Equality Commission, and option 2 was to put in place an interim Annex L, which would allow the department to put in place the updates required to reflect changes in counter-terror and national security legislation, whilst taking adequate time to tease out the implications of the Supreme Court ruling in relation to the Equalities Act. The Minister had asked the committee to provide a response on the proposed PACE Code amendments, outlining its preferred option by Friday the 13th of June. However, members agreed at the meeting on the 12th of June that they were not in a position to make a final decision on this due to the fact that a number of items of requested information had either not yet been received or had been received at short notice, and members had not yet had an opportunity to consider. The PSNI's responses to the queries raised and the list of questions issued following the oral evidence from the Department of Justice officials on the 22nd of May begins at page 26 of the table pack. The committee also asked for the PSNI's view on the proposal to replace some text in certain annexes to under review. However, a response to that correspondence has not yet been received. Members will be aware, however, that the Department has since provided updated drafts of the relevant annexes, which begin at page 359 of the meeting pack. Are members now content to consider the committee's position on the two options set out by the Minister, or do you wish to wait until the PSNI response has been received before considering the committee's position on the proposed amendments to the PACE codes? Bearing in mind that what was sent to the PSNI has now been superseded by the new drafts.
I'd be happy to, or in a position to make a decision today, Chair.
Okay, Connie, thank you. Deirdre?
Yeah, no, well, I would be preferring option one, that we wait until we have all the information. I mean, I'm very clear that, I've laid out concerns, I've asked questions. I don't feel that I have had all of the answers to those questions pertaining around stop and search zones, particularly in sections of the PACE codes that relate to the reserved legislative matters, which I've highlighted before. I wouldn't be comfortable in making a decision when there's gaps in information coming forward. And I would much prefer for that, so that I can take a decision based on all of the information in front of me, and I don't have it at this point.
Okay. Deirdre, can I just check with you in terms of waiting for all the information? You're waiting for stuff from the PSNI and the Equality Commission? Or what else?
PSNI, there was clarification, but it was also in terms of the evidence session with the department. They had clearly said that there were certain aspects, particularly around stop and search, and pertaining to the new Code I and stuff as well, that they would need to go to the Home Office for some of that clarification, because they couldn't answer it. So we haven't had an update on that yet.
Okay. I'll give the DUP's position in a moment, but I don't know whether Justin or Doug want to give their party's position at present. Justin?
Sure, I'm not sure it can be one or the other. Can't be, this isn't black and white. So if we choose wait, what happens in the interim?
Well, it depends exactly what we're waiting for, Justin. If we're waiting for additional information, then we're likely to get that. If we're waiting for revised codes that would take account of the Supreme Court judgment, then that's a much longer, lengthier process in which the department indicates it would need to go out to public consultation, which means that new Code I, which relates to national security, wouldn't be in place. And around some of the Supreme Court gender, sex issues, potentially leaves the PSNI open to challenge. The department and the PSNI are concerned that they may be exposed to challenge. However, it's also important to note that the changes around national security came into being in December 2023. So they've been exposed for a period on that. Now, obviously, the longer that period continues, the greater the risk. So those are the things that we're trying to weigh up. So we can wait for some additional information. We can move on the basis that the longer term solution is in train. Or we can just wait altogether. Now, the Minister hasn't put that option on the table, but and ultimately, the Minister can go ahead and lay these. And then
Surely the Equality Commission guidance is paramount before we proceed.
Yeah, it may be helpful to have some understanding as to when that may come through, but obviously you'll appreciate some of the issues contained within this are not straightforward, highly complex, and that could take some time. But we'll note that that's your preference, Justin. Doug, are you in a position to give an indication at this stage? Doug maybe can't hear me. I think from my point of view, now that we've seen the revised codes, and they really only came in, I would like a chance to speak to my party to determine whether or not we are content, in light of what we heard previously, whether or not we are content to move ahead. And I would like some time to have that conversation with my party leadership. So I'm not in a position to make a decision necessarily today, but that's not to say I wouldn't be in the near future, because certainly I don't want to see the PSNI exposed to any risk, but by the same token, these are serious issues that we need to get right. So we're not in a position to move today. Will we check with the department? I'm not sure the department has given us any indication as to when they expect information. Can you remember if that was raised? If they gave us at the meeting, did they tell us?
It was discussed at the meeting, but there wasn't specifically, and I know it said that there's something to follow up on, but it wasn't specifically something that was formally requested from the department in any written correspondence subsequently, so we can go back to them and ask.
Yeah, and my impression too of that meeting, and I stand to be corrected by the officials or the deputy chair who was also present, was the anticipation is that whatever comes back from the Equality Commission is likely to instigate a much longer term period of work, because that's not straightforward, and it may take them some time to work their way through the judgment. Yeah, and they would publicly consult, and I had said that they would need to publicly consult on any changes that might arise from that. So I don't know if the information from the Equality Commission is going to make any difference at this juncture, but I appreciate that you still have some other areas outstanding beyond the Equality Commission that might enable you to move forward sooner than that. But for now, then, we're not in a position. Do you want to leave this till next week, or do you want to wait for 2 weeks to afford people a chance for the documentations to come in and for people to have further conversations around it with their parties?
I think 2 weeks, Chair, rather than trying to rush it. We do have a meeting then, so and then see what information comes in.
Okay. Do you want to have any further conversations with, if we haven't got a response from the PSNI on the initial under review thing, is it worthwhile asking them if they're content with the revised codes, as the codes as drafted, the new updates on the codes, and checking with the Federation too about that? I mean, if we're going to take 2 weeks, I mean, maybe they could turn it around. If the PSNI haven't drafted a response, maybe we can say scrap that and look at this. You know, and it means we're getting actually up to date information. Yeah. Would that be useful? Yeah. Look, to be honest, I don't want to delay this any longer than we need to, but people need to be comfortable too with where we're at in some of these things. All right. Okay, then that's fine. We'll move on then to agenda item 8, the SL1 on planning fees, which hopefully should be a bit less controversial. Could I ask members to turn to page 406 to 426 of the pack? The Department of Justice is proposing to make a statutory rule under powers conferred by section 223(7) of the Planning Act Northern Ireland 2011, which again would be subject to the negative resolution procedure. The rule amends the planning fees deemed planning applications and appeals regulation Northern Ireland 2025, and will increase the fees payable in relation to applications and appeals to the Planning Appeals Commission. The Northern Ireland Courts and Tribunal Service has responsibility for the administration of PAC, which is the Planning the Planning Appeals Commission, and that's administered jointly with the Water Appeals Commission, WAC. Yeah, so what we're dealing with today is PAC-WAC. The fees replicate the planning fees charged by local councils and the Department of Infrastructure and prescribed in the Planning Fees Regulations Northern Ireland 2025. The Department advises that PAC fees have not been updated since 2015, despite 3 amendments of the DFI planning fees, which was an approximate increase of around 19% since 2019. The Department conducted a targeted consultation with councils and other stakeholders between the 28th of October 2024 and the 3rd of January 2025 and didn't receive any responses. and members can find the post-consultation document at page 417. So are you, first of all, are you content to note the post-consultation document?
Noted, Chair.
Are you content with the proposal for the statutory rule, or do you require any information or clarification?
Content.
Content, yes, I'm content. That's great, thank you. Item 9 is the PSNI retention disposal schedule, which can be found at page 427 of the pack. PSNI retention disposal schedule is required to be laid before the Northern Ireland Assembly under Section 8.2 of the Public Records Act Northern Ireland 1923, and in accordance with the rules of the Disposal of Documents Order 1925 by the Public Records Office of Northern Ireland. The retention and disposal schedule is subject to the negative resolution procedure again. At our meeting on the 29th of May, we considered the R&D schedule and agreed to ask for further information on a number of matters. You'll see that the PSNI's response includes a list of changes and a copy of the previous schedule. It advises that the indefinite category is for biometric material and is new to this schedule, reflecting the Justice Bill is still in progress. The schedule is a live document, and documents will be updated as required to reflect legislative policy. To reflect legislative or policy changes. PSNI has also advised that the Policing Board has no remit in this process because the approval of the schedule is through the Public Records Office and the Assembly. So are members content with the PSNI's retention and disposal schedule version 4 with an implementation date of March 2024, or do you have any additional information or clarification you require? Deirdre.
Yeah, no, thanks very much, Chair. And I suppose just the information that we got back was very helpful. And I suppose the whole area around retention periods has come up, and I actually would have more clarification points that I would like to ask of the PSNI. I have 6 questions that I would ask if the committee would be in agreement. So obviously the category contained within the information around indefinite retention, and that's specific to biometric material. It says within the retention and disposal records that the TACT fingerprints and DNA retained under the Protection of Freedom Act. Now, I've never heard of that before, even in the whole discussions around biometric data, that there's data retained under that act. So I would like to know, are these alternative retention periods, and if so, what are they under that act? Because it doesn't say. I would also want to know if there is a review process for the retention period under the Protection of Freedoms Act. Because again, I just don't know, and I know the review mechanism's something that's come up in the Justice Bill. And then obviously in the PSNI response, they state that both TACT and PACE biometrics taken before the 31st of the 10th 13 are protected by the NI Troubles and Legacy and Reconciliation Act. So again, it's just to ask, how are they protected? Because again, it doesn't give clarity on that. And then the other area, it says also, I can, send this because I know it's probably a lot.
See that RCRIR issue?
Yes.
I think the protection there came from the Legacy Act, where it was agreed that biometrics that related to the troubles and had previously been held by Legacy Investigation Branch would be kept until the ICRIR had completed its work, and at that point would be destroyed.
Well, it was just around where they do state that fingerprints and DNA form the basis of biometric snapshots, obviously used by the ICRIR in the future. But I suppose what I would like to know is what happens to the data once the ICRIR have completed their remit. So is it destroyed, or is it handed back to the original source? And then the other bit around the domestic and child sexual abuse and exploitation, particularly for Category 1 offences. It says here that under the police information guidelines that they carry a minimum of a 100-year retention period with a 10-year review applying to the relevance and accuracy of the information held. So they talk about that an assessment of ongoing business need. So they base it on that. So, but I don't know what that is. What is an assessment of ongoing business need? So I would like clarity on what they mean. That could be an internal PSNI term that I just don't know. And the other bit is this process human rights compliant? And did the Commission have view of the guidelines then around that aspect, or a view of it? Clarity. As I say, I can send the questions on if the committee's content with them. But that's the kind of highlight of them. It's just more information, I suppose, because the information they give us is really good, but it just prompts a couple of more questions.
Yeah, they should stop giving us this information. Right, no, I'm joking. Right, do members want to see the questions before they agree to send them on, or are you content to send them on to the PSNI? Or are you content to approve the retention and disposal schedule and we can still get the answers?
Sure. Just point out that the statutory period is subject to negative resolution, the schedule, so the statutory period actually finishes on, I think this one's the 30th of June. So there are, I suppose there are two separate issues. Are you content with the schedule and still happy to get the additional information?
I would like the information before we make a decision.
I think time will be up by the time you get the information back, I would imagine, because the PSNI, you know, by the time they come back with the information, the committee wouldn't, if you weren't content with it by that stage, the committee wouldn't have time to annul the schedule.
The other issue is, bear in mind, they say it's a live document. It's going to have to be reviewed again once the bill is passed. So it's not going to be your only bite of the cherry. So you could get the information, and if you weren't happy, then you could look to address that down the line whenever we get the bill passed.
I don't know, I just don't, well, from my perspective, I wouldn't be happy until I got the information, but it's up to the rest of the committee what they do, but I wouldn't be happy to proceed.
Okay, well, do members have a view on this? Morris, go ahead. I see your mic on.
Chair, would it make any difference if we delayed it a few days to we get that information?
Yes, Kathy, do you want to explain what the implications are?
Yes, if the committee was to decide it wasn't happy with the schedule, then it would need to actually table a motion to bring it to the floor of the House to actually annul the schedule. But the time to do that, the statutory period expires on the 30th of June, so it would have to actually be annulled on or before the 30th of June. And to do that, then you would need to table the motion for the Business Committee next Tuesday. So you would have to agree today whether you're going to annul it or not.
I appreciate. Go ahead, Morris.
Could we proceed today, whilst at the same time acquiring that extra information that's been required? Could we do that in tandem without actually having to go through the process of taking a motion to the House and having the whole thing annulled?
We can if the committee agrees to do that, yes.
I would propose we do that.
Okay, we know
No
that.
sense losing.
Yeah.
But I'm not precious about it.
It would kind of be my preference, so we would agree the schedule, agree the retention and disposal schedule on the basis that we can still get the answers to those questions, and it's a live document, so it can still be updated. But the issue is if we were to seek to annul that, there's not going to be a schedule at all, so there's no disposal. Go ahead, Connie.
Yeah, I'm happy with Morris's suggestion. I would like to agree that we schedule.
Okay. Deirdre?
Yeah, it's just to note our concerns and for the questions still to be put.
Yeah.
Thanks.
We need the committee to agree that. Right. Justin, do you want to come in on this?
Happy to proceed as suggested. Thank you.
Okay, so the proposal that's on the floor is that we would proceed with it now, but also ask the questions in tandem. Do you want to go to a vote on this? Deirdre, do you want to push this to a vote, or are you content that it proceeds as we've outlined?
We have highlighted our concerns, so
Okay, so we are. Right.
um,
That's fine. Right, so that's agreed, and we'll still in tandem seek the answers to the questions as outlined by the Deputy Chairperson. Okay.
Sorry, Chair, just to be, to square that off, are you content then to inform the Committee for Communities of the committee's decision on the matter, noting the concerns that Deirdre has expressed on behalf of her party, and also that the committee is still seeking further information?
Yes,
on a
members
number of
agreed to
issues?
that? Yep, thank you. Agenda item 10 is the Justice Bill and a raised written paper. You'll find at page 600 to 633 of the pack. You'll know that the Minister for Justice plans to table amendments to the Justice Bill regarding the repeal of the Vagrancy Act 1824 and Vagrancy Ireland Act 1847. The Assembly's Research and Information Service prepared a paper providing overviews of the proposed amendments. Do members have any views on that paper? Do you need any further information or clarification, or are you content to note for now? Because we're going to be coming back to these issues. Ciara?
Just to comment, and obviously to thank Judith for preparing the paper, and I think as we all previously mentioned, we acknowledge the need for the approach for particularly vulnerable people, that they are supported through the engagement of a range of agencies. I also like the aspect of the Belfast Complex Lives model, which is one that I'm really familiar with, previously being the spokesperson for housing. So, and I'm conscious if it's something that the Department of Justice, given how pertinent it is and how effective that model is to support the most vulnerable, that is something that the Department of Justice would look at to drive forward, particularly in other towns and cities. And I have been lobbying quite hard for the past couple of years because I do believe Derry could very much benefit from such a model as well. So it's just to reiterate that with the Minister and the Department on that model.
Okay. Are you content to note this paper for now? And then, we'll come back to it when we come back in September. Content to note for now?
Yep.
Thank you. Agenda item 11 is Justice Bill written papers, starting at page 634 of your packs. Item 11.1 is the response from the Department regarding the biometrics review mechanism. Just a reminder to the background of this, at our meeting on the 22nd of May, we agreed to ask the Department whether any consideration was given to providing an individual whose material has been retained the right to request a review of the retention of that material. We also expressed concern about the potential impact on the development of the necessary IT systems and resulting costs if it's not clear until a later stage how the review mechanism will operate. The Department's response is at page 635 and advises that proposals for a suitable review mechanism are still being developed alongside relevant stakeholders with the aim of producing a suitable, proportionate draft review model that will be as efficient as possible for the PSNI to operate by autumn 2025 for the Minister's consideration. We're not entirely clear from the response whether an individual will be able to request a review, but we'll wait and see. The Department also advised that while software development is a matter for the PSNI, it understands that the PSNI's intention is to develop a package that integrates review and retention dates. Furthermore, the Department states that it anticipates an 18 to 24 month window between royal assent of the bill and implementation, and that it will progress the review regulations as soon as possible following royal assent to deliver certainty at the earliest opportunity and thereby enable the PSNI to develop a system that presumably incorporates those issues. Are you content to note that response, or do you require any further information or clarification, Deirdre?
Sorry, Chair, thank you. Yeah, and I suppose I'm a bit concerned in terms of what's not in terms of timescales and stuff. I know they talk about autumn, but I would like, in terms of the committee, to come back to this in the autumn.
Yep.
And doing a wee dedicated kind of session looking at the review mechanism, because it is one of the areas from the Commissioner in Scotland to the ICO to the Human Rights Commission and others that they've said, and obviously the fact that it's not in the face of the bill as well is also concerning. So rather than trying to deal with it all now,
Yep.
if the committee could take a particular look then at this response and then what we could do, and even to give time for the Department, if they're saying that discussions are going to go on over the summer, will they have a further update for us at the autumn period then after recess? Thanks.
Right, are members content to proceed in that direction?
Content, yeah.
Thank you. 11.2 is from the DOJ again. It's delegated powers memorandum for the Department's amendments. You'll recall that we had requested that the Department provide a copy of the delegated powers memorandum for the planned departmental amendments to the Justice Bill. The response containing the memorandum can be found at page 639 of the pack, and the department has stated that officials would be happy to meet with the committee clerk and the examiner of statutory rules should any further queries or clarification be required. At this stage, our members content to request advice from the examiner on the delegated powers memorandum and invite the examiner to provide an oral briefing after the summer recess.
Yep.
Great, thank you. 11.3 is from an individual, and it's consent for publishing a call for evidence submission. You'll remember potentially that we received a submission from an individual in response to our call for evidence on the bill, and that individual had forwarded their submission by way of a handwritten letter, and it didn't come through the online portal, and the committee hadn't received confirmation of consent to publish the submission on the web page. So the clerk responded to the individual to seek that consent. That individual has now come back to the clerk and has made some additional observations in his correspondence, and you can find that at page 648. Are you content to note that response and for the submission to be published on the committee website? Great, thank you. 11.4 is Justice Bill request for further information, and you'll find that at page 650, and that's just the list of the committee's requests for information on the bill and the responses received to date. Are you content to note?
Noted.
Thank you. Item 12 is the repeal of vagrancy legislation. It's the consultation responses and the way forward. And again, it's a written paper from the Department of Justice. You'll find that at page 677 of the pack. The Department provided a written update on the consultation on the repeal of Section 4 of the Vagrancy Act 1824 and Section 3 of the Vagrancy Ireland Act 1847. 11 responses to the consultation were received, and the summary of responses and next steps of the consultation is at page 681 to 701. The Department advises that, and this is a quote, given the support received for repeal in responses to the consultation, draft provision enabling repeal of Section 4 of the Vagrancy Act 1824 and Section 3 of the Vagrancy Ireland Act 1847 will be tabled at consideration stage of the bill. Are you content to note that paper, or do you require any further information or clarification? I think at some stage we're going to need to explore any issues in relation to what kind of who we want to bring in to hear about that amendment, and the consequences of it, unintended or otherwise, and just to take some evidence on this area in the bill, because we haven't really looked at it yet. So does anybody have any initial thoughts about that, or do you want to just give some consideration to that over the summer and we can come back to it?
Yeah, we could do. I know one of the areas, I think it was in one of the earlier papers, we'd looked at in terms of some of the allowances in the south, in terms of the guards and stuff, around bank links and things, but maybe we can just come back to that in the autumn. And I know we met the police, so I don't know if there's a need to get them in again around, other...
Well, if we're having them in, I think there's none that precludes us from asking questions. I think we'll need to look at this amendment as we need to look at serious organised crime and stuff, because we haven't really given consideration to that, and we had already agreed that we would speak to Glasgow and Aberdeen Council, because initially they had expressed some concern about similar legislation in Scotland, and it's just to establish now, I suppose, whether they're happy and how they find things. So that's certainly something we are going to look at, but I think there are a number of places we need to look just to take further evidence on this bill, because I want to make sure we have the ground covered on everything. Deirdre, do you want anything?
Maybe some of the homelessness organisations might be worthwhile as well.
I think in particular what we need to look at here is the homelessness organisations and actually the business community. We need to be hearing, because it's one thing to repeal this, but we need to make sure that people who find themselves in these situations, nobody wants them criminalised, but they also need help. And if they're not on anybody's radar, how do we ensure that that's taken forward? And there are unintended consequences, and we just need to make sure that that the whole thing is looked at in a holistic way. So members are content with that. Ciara?
Just for the clerk, probably the City Centre initiative within Derry, who would work within the PSNI, the supporting people, the housing, all those kind of stakeholders in this field, very much would lead on that in the city, so it would be another point of contact when it comes to evidence base as well.
Yeah, that'll be useful. I think we want to be sure we've covered the ground and heard all aspects, so that'll be great. Thank you. Agenda item 13 is Private International Law Implementation of Agreements Act 2020, and it's a proposed extension of Section 2 Power Department, and it's a written paper from the Department. You'll find that at page 702. At our meeting on February the 27th, 2025, we considered correspondence from the Department regarding the Minister's intention to seek the agreement in principle of executive colleagues to a proposal by the UK Government that a statutory instrument be made at Westminster, subject to the outcome of a targeted consultation, to extend the power in Section 2 of the Private International Law PIL Agreement of PIL Implementation of Agreements Act 2020, and this would include Northern Ireland. At that meeting, we agreed to ask the Department for more details and background information to the proposed statutory instruments. We noted the response at our meeting on the 20th of March, in which the Department advised that, given the Section 2 power is cross-cutting, the Minister referred the matter to the Executive, which agreed in principle, subject to the outcome of the government-led consultation, to Section 2 power being extended for a further 5 years in relation to Northern Ireland, and to the proposed statutory instrument to be made at Westminster for this purpose, including Northern Ireland. Department has now advised that the Government's consultation, which included Northern Ireland stakeholders, concluded on the 29th of April, and the Minister has recently received correspondence from the Parliamentary Under-Secretary of State for Justice, advising that consultees who responded were generally in favour of extending the power. The Parliamentary Under-Secretary of State for Justice will therefore now proceed to lay a statutory instrument in Parliament. The Department further stated that the proposed statutory instrument will simply extend the period during which the Section 2 power is available, essentially maintaining the status quo. So any future substantive exercise of the power would be a matter for the Northern Ireland Department, with policy responsibility for the subject matter of the particular PIL agreement to be implemented. So are you content to note that paper, or do you require anything further? Content to note?
Noted, yeah.
Thank you. I wish you'd been content to note without me having to read out all that. Right. Agenda item 14 is correspondence. There's a correspondence memo and 10 items of correspondence starting at page 712. I'm going to draw your attention to a number, and then I'll open the floor for members to raise anything they want to raise or comment on any other items in which they've got an interest. So let's start with item 14.2 to 14.4, starting at page 715. And that's correspondence from the Department of Justice, the Department of Health and the Police in response to the DOJ and DOH's Improving Health Within Criminal Justice Strategy Action Plan report. I just want to draw your attention that the police custody health needs assessment is marked office sensitive and commercial. Are there any, should that be office or official? Official, sensitive and commercial. If there are any comments to make on these responses, or do you require any information or clarification on anything, or are you content to note those items of correspondence? Ciara?
Just on that, can you clarify again, just did you say the North of England Commission support report is 14.3?
The police custody health needs assessment?
The police custody health needs assessment?
Yeah.
Okay.
So that's the big long report in the tabled pack, isn't it?
Mm-hmm.
No, not in the tabled pack, it's in this one actually, isn't it? It's in the main pack.
The main pack, sorry.
Yeah. So that's the one that you'll see it's marked official, sensitive, commercials, which means it can't be shared and shouldn't be.
Those are actually 14s as well. Sorry, this was late last night. 14.
Yes.
2. Sorry.
That's all right. So, do you require anything else, or are you content to note?
I have just a couple of questions, but I've kind of been putting 4.1, 4.2 and 4.3 collectively together, because it was very much health and justice and how they collaborate and work. So stop me if I'm speaking out of turn. I suppose around the social care aspect of it, pleased to see obviously they've commissioned a report in January 25, and a final report once received will inform discussion way forward. So once again, it's just sketchy. We've no timelines. Who's undertaking the contract? And I think based on our previous conversation, is that going to be done in-house internally, or has it been commissioned externally? So have we got timelines for that? Likewise, the partnership agreement between NIPC and the Department of Health is currently under review. and the provision of social care will be reflected in that revised agreement. Once again, I wouldn't mind knowing when's the timeline, so at least we can expect progress on both. And then likewise the multi-agency workshop, which is planned for the 30th of June to address the way forward in adult safeguarding. Once again, with no timelines or next steps. So I'm just kind of disappointed in the responses. I'm asking more questions. I don't think it's pertinent maybe in future when we are asking questions that we ask directly for timelines, because I'm assuming if they're starting a process, they've got a schedule of work with at least an estimate timeline. Likewise, regarding accommodation, which we know is a huge issue regarding leaving accommodation. So there is a protocol, and if that's available, it's published. Is that publicly available, just to find out where can we access it? I'm assuming then if it's published, it's maybe published online somewhere, so it'd be useful to find that out. And then likewise, just in relation to the response from the Department of Health, these are a range of questions that we previously asked a few weeks ago. The draft outline business case for the 4-tier model on personality disorder developed. Like, what's next? So it's developed. So I'm curious. Well, because it's developed, what's the plan? The waiting times for the psychiatric beds. It does vary, but I'm still very concerned, particularly given the scale and the length of time. Some waiting up to 3 months. What's the impact? Have they looked at what is the impact on the prison staff? What's the impact been on the actual prisoners themselves, and the impact on, and the knock-on impact of other services, given probably the range of support that's needed for those that actually require hospitalisation within a psychiatric bed and not in a prison. So I'd like more information on that regarding have they carried an impact assessment. The health needs assessment, which we're aware began back in 2020, has been ongoing for the last 5 years. They mentioned that there's some reports and there's some sections near completion. So I'd like to know, well, because there's only some sections, what are those sections? What staff resources dedicated? And when are we going to actually ever get a final report, knowing that it has gone ongoing this last 5 years? Likewise, the NI ambulance service here and Treat Pilot, and that's obviously with mental health professionals in control rooms. And I'm delighted that they have found slippage to continue it so they can monitor and evaluate it. So it's basically just a timeline now for the slippage. How long will that continue? How long will the evaluation process take? And for next steps, because it seemed to be something that is very positive, but once again, no timelines for it. And then just section 14.3, that report from the North of England on the commissioning to complete the health needs assessment across the police custody suites in the North. Is this the one you're saying is restricted?
Yeah, that's
Section 14.3. Right, so obviously I'll say no more, but there is a list of at least 12 areas of concern that I would like to maybe discuss and highlight, but
14.4, sorry.
no, it's 14.3 that I'm
Hold on a
referencing.
minute, Ciara, did I get this up to see where I am here?
14.3.
It's the North of England commissioning with
Yes,
PHE.
it's the PSNI one that's restricted,
So this is the custody suites.
isn't it?
Yeah, the health needs in the custody suites, no.
The health needs assessment across the custody suites in the North, yeah.
14.4, that is, I think.
Yeah,
Oh, it was
that's-
14.3,
yeah,
must be on my
Yes.
notes.
Yeah.
So that is restricted?
Mhm.
Okay.
It depends what you want to ask, though. It's just to be mindful that there might be commercial sensitivities, that's all.
So
you
don't
know,
be quoting
so-
the paper, don't be, if you've got questions you want to ask, maybe you want to send them through and we could approve them by email or something, would that work?
Yeah. But I think
Rather than raise them in the public forum where it's being broadcast on YouTube and so on.
Okay.
Would that
Yeah.
work for you?
Yes, I'll email.
and I'll circulate them to all members.
Yeah.
Right. In the interim, are we content to progress Ciara's other questions? Yep, I mean, I think some of those responses are fairly short and there's very little detail in them, to be honest, so. Members content, yes?
Right.
Thank you. Item 14.9, page 839, and that contains an invitation from, let let me just get it myself up, 839. That contains an invitation from NIJAC, which is the Northern Ireland Judicial Appointments Commission, for an engagement session between them, us, and the Executive Office Committee. Are you agreed to allow the clerk to liaise with NIJAC and the Executive Office Committee clerk to arrange a suitable date for the engagement session? Yep. Can I just check, the dates that they've offered are all Monday mornings. Now it's that 9:30, 12 slot, so people might potentially have to miss group meetings, but you'd be missing very little of plenary, unless we cut things short or invited them here instead. But by and large, are members okay with the Monday morning slot? The trouble with it is, I mean, TEO meets on a Wednesday, we meet on a Thursday. To do it on a Friday is constituency day, and we all get, far less time than we would like in our constituency. So to move it away from a plenary day makes it quite difficult.
Is there an option for like a Tuesday morning? Because then you're missing, I know it starts at 10, but if you did 9 AM on a Tuesday, you've got member statements at 10:30, the business doesn't really start. If you're not doing a member statement, then you got until like 11. Or is that, people don't want to miss plenary? Just, it would be tricky, because I know we all then have meetings Monday morning, and you wouldn't.
Yeah, although we would end up missing less of plenary than we would on a Tuesday, on a Monday, if you know what I mean.
Okay.
Because they're proposing 3 hours.
Oh right, okay, they're proposing 3 hours.
Yes.
Oh right, sorry. Okay, if they're proposing 3 hours, we'll be missing
Are you
some.
realistically going to get both committees for 3 hours?
No.
No chance.
No, you won't.
No.
But the issue is, I mean, the difficulties we've had before when we had joint meetings was a quorum. Now, this may not be formal enough to have a quorum, but the issue with it is, I don't want us to be embarrassed. I don't want us to have circumstances where there should be 18 people in the room and we're sitting there with 2 or 3.
I think, sorry, Chair, what I would like to find out as well for the committee is a little bit more about what it entails and why it's 3, what the plan are for the 3 hours. And so if members are content, I can take it away and look at all of that.
Yeah, we'll get Kathy going and look at that. But what I wanted to establish was, right, if it is going ahead on a Monday, are you all right with that?
Yes.
It's not ideal.
I know, I'll have to get back to you, to be honest.
You'd miss more on a Tuesday.
It might be a case that you'd only have like one person from the party, across the 2 committees.
Right. Item 1410 is at page 840 of the pack, and that corresponds from an individual to the committee regarding personal matters. We've previously considered a number of items of correspondence from the individual on these issues. Can I seek to your agreement to respond, just reiterating our position that this committee has a strategic policy and a legislative role in relation to justice matters and does not become involved in individual complaints, and advise that local elected representatives may be able to assist. Are you content with that?
Yep.
Right. Are you content to note the other items of correspondence, or do you have anything else you want to raise from amongst those?
Noted.
Okay, yeah, they weren't too bad this week. Agenda item 15 is the Forward Work Programme, and there's a draft of that at page 905. Just a reminder that there's an informal roundtable event with children and young people to seek their views on the Justice Bill, and that's going to take place in the Lawn Gallery on Thursday, the 3rd of July, immediately following a truncated committee. Could members indicate now, if possible, whether or not they plan to attend the roundtable event?
What's the timings on that, just Chair? Sorry.
It'll be the usual committee time, Steve. So
Instead of the committee?
there'll be a truncated meeting just the way we did with the last
Just
roundtable,
a
so
short
we'll be
one,
in here
yeah.
first
No, that's okay.
and then head up the stairs.
Yeah, I'll be
I'll be there.
Yeah. So
I might have to be an apology, Chair, but just not confirmed yet. I would be able to join online, but obviously you can't do a roundtable online, so I would be able to join the first bit of the committee online.
okay.
But I'll let you know once I'm
Yeah.
sure.
Morris, Doug and Justin can let us know in due course, then I'll be there too. Right. Are you content to agree the Forward Work Programme?
Yeah, Chair, I'll be all right. Sorry.
Morris, that's great. Happy days. Thank you.
Yeah, I'll be.
Right. Content to agree the Forward Work Programme? Yep.
Yep.
Thank you. Chairperson's business, page 910 in the pack, you'll see there's an invitation from the Lady Chief Justice for me to attend the opening of the legal year on Friday the 5th of September. Are you all content for me to attend that as chairperson of the committee?
Yep.
Yeah.
Thank you. The other thing I want to flag up is you'll see that the Legal Services Oversight Commission issues are coming up on Tuesday in the Assembly. Do members want me as chairperson to flag up work the committee has undertaken thus far on that, or are we just content to let the finance committee members carry on? Do you have any strong views on it either way? I don't.
I no strong views either way, to be honest.
All right. No, we'll just, that's fine.
Chair, can I just say, we have received some, because the committee has requested some information, so we have received some information back from the Finance Committee, have written to us as well, just this afternoon, and from the Department of Finance and from the Department of Justice, and we will circulate, it'll be in the pack on Monday, but we'll circulate it before that so that you've got it, make sure you have it before the debate on Tuesday, I think. Yeah.
Okay. Any other business? No? Date, time, place of next meeting? Next week, which is the 26th of June, 2 p.m. in this room. The meeting is adjourned. Thank you very much, everybody.
Committee Room 30, sound.